I'm very pleased to welcome all of you here to this morning's event, judicial panel discussions organized by the Coalition for the International Criminal Court. My name is Kirsten Meerschaert, and I'm the Director of Programs with the Coalition. The Coalition for the ICC is a network of more than 2,500 non-governmental organizations in 150 countries, working in partnership to make sure that the court is fair, effective, and independent, to make justice both visible and universal, to strengthen international cooperation with the court, and to advance stronger national laws that deliver justice to victims of war crimes, crimes against humanity, and genocide. I am very honored to be here this morning and to welcome you. And I would like to express our deep appreciation to the host state of the Netherlands for hosting these discussions today as well. And I would like to invite, if I may, Ambassador van Ijssel to take the floor.
Thank you very much. Your Excellencies, ladies and gentlemen, good morning to you all. It is a special privilege to speak to you today because, like I think all of us, it's my first time in this new hall in this new Ministry of Foreign Affairs. So if things go wrong, blame us. We have to get used to the premises as well. In a way, we are testing out the facilities with this meeting. No, that's not completely true. But still, it is a first time, so we hope everything is going well. As was said, my name is Paul van Ijssel. I'm the new Dutch permanent representative to the International Criminal Court, and I'm looking forward to work with all of you in the coming years. It is, of course, a pleasure to welcome you here to today's panel discussion with the ICC judicial candidates here, as I said, at this new premises of the Netherlands Ministry of Foreign Affairs. A special welcome to the 12 candidate judges. And I'm very pleased. I mean, not all of you are here yet, but I'm told that during the day you all will come, and I'm very pleased that you're able to make it to The Hague from all corners of the world. Let me underline that today's event is organized by the Coalition for the International Criminal Court, which is a truly global civil society network of over 2,500 member organizations in 150 countries. We today act merely as a host, as I would say the locus delicti of today's event. Please allow me nevertheless to say a few words on this important occasion. 15 years have passed since the entry into force of the Rome Statute, and much has been achieved since then. The International Criminal Court has firmly established its credibility as an independent and effective international criminal court. In 15 years, the prosecutor has opened investigations in 10 situations of crimes committed in 9 countries, which resulted in 9 convictions and 1 acquittal. 3 trials are now ongoing against individuals that include a former president, as well as leaders of militia and terrorist groups. But we think that the impact of the court has been much bigger than that. Through the complementarity approach, the ICC has contributed to creating a system that obliges states to ensure individual accountability for the most serious international crimes. As the president of the court regularly underlines, the court, rather than being one tribunal, is one tribunal plus the domestic systems of the states, by thus ensuring accountability and bringing justice to victims, and hopefully such crimes are prevented as well. Excellencies, ladies and gentlemen, while the achievements of the court are indisputable, it is also evident that the court continues to face important challenges. In many regions, access to justice for war crimes, crimes against humanity, and genocide is a dream rather than a real possibility. The court, states, non-state parties, international organizations, and last but certainly not least, civil society, all share the responsibility in realizing the mission of the Rome Statute. The future judges of the ICC will be at the forefront of this endeavor. We think, therefore, it's very important to have a transparent, fair, and merit-based process so that states are able to make a well-informed decision and thereby strengthen the court to fulfill its mandate. I'm therefore very pleased to see that so many of you came today to this venue to get further acquainted with the candidates. I wish you all a very successful and a very informative day. I thank you very much.
Thank you very much, Ambassador. I would also like to thank you and all of your colleagues here at the Ministry of Foreign Affairs who have helped arrange for us to be in this impressive setting this morning. I'd also like to echo the gratitude of the Ambassador to all of the candidates who have made themselves available for these panel discussions today, which seek to enable the nominees to expand on their respective qualifications and expertise, as well as to promote fully informed decision-making by states parties delegates. The convener of the coalition, Mr. Bill Pace, also sends his thanks, as well as his regrets for not being able to be here today. As you may well imagine, other important ICC and international justice-related meetings are taking place in New York during this high-level UN General Assembly week. A few points of logistics. English, French-English interpretation is available, and I would already like to thank the interpreters for their assistance today. For those who are attending this event in person here in The Hague, please note that should you wish to leave the premises of the ministry, you must return your badge, and in order to re-enter the ministry, you must re-register downstairs. Today's event is being recorded and live streamed, and for those who are watching us from afar, they may join in on the discussion on Twitter by using our Twitter handle @NGOs4Justice and the hashtags #ICC-elections and #electthebest. As Ambassador van Ijssel stated in his welcoming remarks, the Ministry of Foreign Affairs and the Coalition for the International Criminal Court wish to emphasize that these judicial panels are an independent event of the coalition. Indeed, today's event is part of a long-standing, comprehensive campaign undertaken by the coalition in the firm belief that the ICC will only be seen as a truly independent, fair, and effective international justice mechanism if its chambers are composed of only the most highly qualified judges. Since the court's first judicial elections in 2003, the coalition has helped publicize and raise awareness about ICC elections and the candidates, including by preparing detailed memos on the nominations and elections processes. At the 16th session of the Assembly of States Parties in December 2017 in New York, 6 new judges will be elected to the ICC bench. Today's panel discussions are meant to provide an opportunity to learn more about the candidates' qualifications, experience, and expectations for international justice. In addition to organizing such public seminars, the coalition asks all nominees to fill out questionnaires that provide additional information about the candidates' qualifications. I'm very pleased to note that all 12 candidates have completed these questionnaires, and their questionnaires are available on our website at www.coalitionfortheicc.org. The coalition as a whole does not endorse nor oppose individual candidates, but advocates for the integrity of the nomination and election procedures. As such, the coalition strongly opposes reciprocal political agreements or vote trading in ICC elections. In a moment, I will ask candidates to introduce themselves for about 5 minutes each, and then I will open up the floor to questions from the audience. When we move to the Q&A portion, I would kindly ask those requesting the floor to refrain from making statements or comments and to simply pose questions addressed to the entire panel. I would also exhort you to not ask any questions pertaining to a preliminary examination, an investigation, case, or any other matters sub judice before the International Criminal Court. It is my pleasure now to offer the candidates a moment to introduce themselves to our audience today. And I would like to start with Ms. Majara.
Thank you very much, Madam Moderator. Oh, thank you. Thank you very much, Madam Moderator. I am Justice Nthomeng Majara. I am a judge from Lesotho and the current Chief Justice of the Kingdom. I am qualified as a lawyer, having studied law at the National University of Lesotho in my formative years. I hold a BA law degree, that is a Bachelor of Arts in Law, a Bachelor of Laws degree, and a Master of Laws degree, which I obtained from the University of London from King's College. I have served as a judge for the past 14 years, 3 of which I've been serving as the Chief Justice. Before then, I was a magistrate for 10 years, where I dealt mostly with criminal law and procedure. After that, I joined the Faculty of Law at the National University of Lesotho, where I taught, amongst others, criminal law and procedure and criminology. After that, I joined an NGO in the SADC region, which is known as Women and Law in Southern Africa Research and Educational Trust, which basically looked into how the law affects women and children, with the aim to make recommendations to the authorities to change the laws to make them better in the way they respond to challenges that are peculiar to women. It was after that that I was appointed to the Superior Courts of Lesotho, namely the High Court and the Court of Appeal. But the peculiarity of the Superior Courts is that the Court of Appeal is only a sessional court. So even as a Chief Justice, my seat is in the High Court, but in terms of the constitutional provisions, I'm an ex officio member of the Court of Appeal, and I've been same ever since I was first appointed as an acting judge in 2004. The reason why, in spite of being the Chief Justice of the Kingdom, I felt I should apply to be elected as one of the judges to serve at the International Criminal Court is that I believe I bring with me something that is different. I'm a woman. I'm the first female Chief Justice in the region. I have dealt with criminal law for most part of my professional life. I believe I bring a wealth of experience coming from a common law jurisdiction, which is not very different from the jurisdiction or the system that applies in the ICC. I also bring an African perspective from a very small kingdom. I've dealt with women issues, and I believe it is only fair that the ICC is fairly representative, gender-wise, geographic-wise, and I think I make the cut. That is about it.
Thank you, Ms. Majara. I would now pass the floor to our second candidate on the panel. Ms. Bossa, you have 5 minutes.
Thank you, Moderator, Your Excellencies, members of the Coalition for the International Criminal Court, and all of you distinguished participants. I thank you for coming and for affording us this opportunity to put across our various experiences and suitability for the post of judge to the ICC. My name is Solomy Bossa. I come from Uganda. I'm a judge on the Court of Appeal for Uganda. And I'm also a part-time judge with the African Court of Human and People's Rights, as well as the residual mechanism of the International Criminal Tribunals. My work as a judge expands over a period of 20 years now. And in this 20-year period, I have served on these various courts and handled international criminal trials, both with the United Nations International Criminal Tribunal for Rwanda and currently with the United Nations Mechanism for International Criminal Tribunals. I've handled complex criminal trials. I've handled sexual and gender-based violence in these trials, and I continue to handle them, both in internal, non-international conflicts and international conflict situations. As a judge on the African Court, I try cases which are brought by individuals against states for grave violations of human rights. When we find a violation, we order reparations. So I'm also familiar with this concept. At the national level, I began as a judge of the High Court, and this court has unlimited jurisdiction, and I handled a lot of criminal trials as well as family cases because I initially sat in the family division and criminal divisions. Before I joined the bench, I was a lawyer in private practice and an activist. And in this role, I represented indigent women to ventilate their rights regarding matrimonial property, custody of children, violence in the home, and other related aspects of this type. I also represented a number of indigent appellants and accused persons at trial level and on appeal level regarding murder, manslaughter, and I continue to handle rape and defilement. Defilement is the rape of minors in Uganda. I continue to hear appeals in this regard at the Court of Appeal. My decision to offer myself as a candidate is based on my experience in this regard. I sincerely believe that I can make a contribution to the ICC because I'm passionate about justice, particularly for grave crime, and I believe in bringing to account those people who commit grave crimes against innocent people. So I hope that my experience will help in improving the independence and effectiveness of the court because I'm familiar with courtroom experience, I'm familiar with control of proceedings, the rules of procedure and evidence, and collegiality that is essential for a panel sitting to come up with decisions quickly and fairly. Basically, that is why I've offered myself as a candidate for the ICC. And I hope that my experience will benefit the court. I thank you.
Thank you very much, Ms. Bossa. I will now turn to the candidate on my left, Mr. Chagdaa.
I would like to express our gratitude on behalf of Mongolian government for the coalition for International Criminal Court for organizing such important discussions, and to thank distinguished guests for coming to hear us. My name is Judge Khosbayar Chagdaa. I represent Mongolia. The government of Mongolia has nominated me as a candidate for the elections of judges at the ICC, which will be held during the 16th sessions of the Assembly of State Parties, scheduled to take place in December of this year. I stand for election under List A for the purpose of Article 36, paragraph 5 of the Rome Statute. For the purpose of Article 36, paragraph 8A of the Rome Statute, I am national of Mongolia will represent a civil law system in the Asia Pacific group. My curriculum vitae is available on the ICC's website. I believe I met the requirements in Article 36, paragraph 3 of the Rome Statute, since I am currently serving as a justice at the Supreme Court of Mongolia, the highest judicial office in the country in criminal matter, and have held this post since April 2015. I have established competence in criminal law and procedure and have the necessary relevant experience as an advocate, investigating prosecutor, and as a judge in all instances of judiciary in Mongolia, thus fulfilling the requirements of Article 36, paragraph 3b(1). I started my career as an advocate at the Mongolian Advocates Association, specializing in the juvenile crimes and human trafficking involving women and children with the purpose of sexual exploitation. And I also served as investigating prosecutor over exclusive jurisdiction in the investigation unit under the General Prosecutor Office of Mongolia, which is responsible for investigating cases, criminal cases involving law enforcement and judicial officers such as police officers, prosecutors, judges, special service agents, and court marshals. Consequently, I have attained multifaceted experience in every aspect of criminal proceedings by assuming various positions. I have continued my professional career as a judge and acquired substantial experience in this position too. In the course of my career as a judge from 2006 to 2012, I served on the bench of first instance court, dealing with complicated, high-profile cases involving high-level officials such as the former president of the state, head of National Police Department, as well as several parliament members and cabinet ministers. Between 2012 and 2015, I worked at the Capital City Court of Criminal Appeals. And in 2015, I was appointed as a judge at the Criminal Division of the Supreme Court of Mongolia. During my entire career as a judge, I served for over 11 years in various courts of Mongolia, handling over 4,000 criminal cases. I earned my BA degree in Mongolia, which has a civil law system, but I received an LLM degree in common law from the Brigham Young University in United States of America, and has completed internship at the 4th District Court of Provo in the USA too. I had acquired additional legal education as a research scholar in Netherlands, France, and Hong Kong. And I'm an adjunct professor for advanced criminal law and advanced criminal procedure, and a PhD candidate at the School of Law of the National University of Mongolia. And my doctoral thesis, I researched the problems of implementation of treaties by national courts of Mongolia. In addition, I have extensive experience in drawing criminal justice reform in Mongolia. From 2011 until 2016, I was a member of the governmental committee for drafting new penal code and new criminal procedure code of Mongolia, and participated in elaboration of the Tort Law, Law Enforcement Act, and Marshal Service Law of the state. In this capacity, I actively participated in establishing the legal framework and a new approach to Mongolian criminal justice, and contributed to consolidating the priority of principles of universal jurisdiction, non-applicability of statute of limitations, and complementarity for the crimes within the jurisdiction of the International Criminal Court. Currently, I'm a member of the governmental committee, which is responsible for drafting the amendments to the new penal code and new criminal procedure code of Mongolia in full compliance with the treaty standards. Thank you for your attention.
Thank you, Mr. Chagdaa. And now I'd like to give the floor to Mr. Đurđević. Ms. Đurđević, sorry.
Good morning, everyone. I'm Zlata Đurđević, a candidate for judge of the ICC of the Republic of Croatia. I would like to thank first to the coalition of the ICC for organizing this event and for giving us opportunity to represent to you our expertise and our knowledge in this field. I am a professor of criminal procedure law, international criminal law, and human rights law at the University of Zagreb. I hold the master's degree and PhD from the University of Zagreb, but also the master's degree in criminology from the University of Cambridge. I passed the bar exam in 1994, so I have 25 years of experience at the university, but also in the judiciary. I'm a candidate of the Republic of Croatia at the list B, as I am a professor of international criminal law, human rights law, and also international cooperation in criminal matters. I'm visiting at the University of Zagreb, but also I'm a visiting professor of international criminal law at the University of Luxembourg. In last 2 years, 2015, 14, and 16, I was at the Yale Law School, where I was a senior research scholar doing research in international cooperation and human rights. With regard my expertise in human rights law, I have dealt, researched, giving lectures in many human rights issues related to criminal justice. So I can consider myself an expert with regard to fair trial rights, defense rights, right to life, prohibition of torture, effective investigation, right to privacy, and all other rights which are relevant for criminal proceedings. I have also introduced the course Human Rights and Criminal Justice at the University of Zagreb, but also gave this course at the University of Berkeley as a visiting professor in 2010. As concerns international criminal law and procedure, I'm teaching that subject at 2 universities, and I wrote lots of papers in all these fields, including international criminal law and international cooperation. Particularly during my stay at the Yale Law School, I wrote a paper about the enforcement system of the ICC, blurring the distinctive feature of the criminal courts. Although I'm a candidate on the list B, I also have a qualification with regard to list A, as I am professor of criminal procedure law. That's my main field of work. I'm head of Department of Criminal Procedure Law for 7 years. I also was the president of the working group of the Ministry of Justice dealing with the new Criminal Procedure Act. As a professor in Croatia, I participated in a judiciary by giving legal opinions at the first instance court, 7th Eastern Court for the criminal proceedings, but also for the Constitutional Court and European Court of Human Rights. In last 2 years, I also participated as the expert witness for the arbitral proceedings before the UNCITRAL and ICSID in arbitral proceedings Mol versus Republic of Croatia. So I can only conclude that I am confident that I have all the knowledge and specialization and expertise which is necessary for the International Criminal Court with regard to international criminal law, international humanitarian law, human rights law, but also criminal procedural law and criminal law. To be the judge of the International Criminal Court, although we have these 2 lists, I think they are necessary only for election procedures. However, the judges have to have expertise in all these fields, as it is a criminal court that is running in criminal proceedings to establish international criminal responsibility in application of international standards which are prescribed by international conventions. I'm confident that I can work with other colleagues. I have expertise also in civil law, as I'm coming from the civil law country. However, I spent a lot of my education abroad at Cambridge, Berkeley, also Yale University, and studied there and doing my research. So I have also extensive knowledge in common law issues related to criminal proceedings and evidence. thank you for now, and I am looking forward to your questions.
Thank you, Ms. Đurđević. Thank you to all the candidates for those brief introductions. I'm very pleased now to open the floor to our audience, the audience that's physically present here in The Hague, or those who are watching us from someplace else and would like to address a question through our Twitter handle or other social media. So if anybody would like to ask a question, I would ask you to please raise your hand and somebody will come with a microphone if you are not seated by a microphone. And again, I would just remind you to please refrain from making comments or statements in relation to anything you may have just heard, but rather to direct questions, focused questions, to the entire panel. Okay, I see a question here on my left, please.
Thomas Fairfuss, journalist for Justice. As judges of the ICC, you will be tasked not only with judicial proceedings, you will also be tasked with contributing to the further development of the system, which is still a rather young system. That role is formalized in your task as members of the plenary of the court to propose amendments of the rules of procedure and evidence to the Assembly of States Parties. And more in general, you have an informal role in advising States Parties about the changes the system may need. So, as you are candidates for a judgeship now, I imagine that you have observed the court closely for many years. And I wonder if you have certain opinions about how the system needs to be developed further. I can think of two aspects that might be interesting to hear your views on. Firstly, if we think of contempt or offences against the administration of justice, as it is called at the ICC, there is the problem that the Rome Statute provides only for the office of the prosecutor to investigate and prosecute, even if it is its own staff that is a suspect. Whereas the creators of the system had the example of the Tribunal for the former Yugoslavia, where a trial chamber, when a suspicion of contempt arises, has the choice between different means, prosecution by the OTP or amicus curiae, or by the chamber itself. So this is one point. One may wonder whether the system needs improvement, inspired maybe by other international tribunals. A second point I'm thinking of is when I look at the dissatisfaction of the public and in general, and groups of victims in particular in some situations, about the prosecutor not prosecuting. One may look at certain national mechanisms, national systems where mechanisms are provided for citizens that are not satisfied with a prosecutor not prosecuting. Here in the Netherlands, a victim or another interested party can ask a court of appeal to order the prosecutor to prosecute. In Germany, it's a crime for a prosecutor not to prosecute when there are indications of a crime. Whereas at the ICC, there is no mechanism at all to checks and balances if the prosecutor does not prosecute. So these are two aspects I can think of where the system might need approval, but I'm also interested in other views you might have on how the system needs to be developed further. Thank you.
Thank you very much. So I would like to offer the candidates an opportunity, each of you, to come back and address this question, which I would sum up, if I can focus it a bit, as to where do you see your ability to contribute to the further development of the International Criminal Court and the Rome Statute system. The question did raise two specific examples. Please feel free to address those within the limits that you feel are suitable for your candidacy. In other words, that it would not in any way impact somehow a current or future investigation, case, or preliminary examination before the ICC. Perhaps Ms. Đurđević, I can begin with you this time.
First, to say that one of the challenges for the ICC is certainly its procedure, its evidence law, the length of the procedure, which has been actually addressed a lot in the last years by the ICC, as the current ICC judge has made its top priority to make the ICC expedient and more efficient court. As a professor of criminal procedure law, I am completely confident that I have knowledge which can help a court to make its procedure more efficient and more expedient. What has been done until now by the court is certainly to shorten the pre-trial proceedings and also the phase of confirmation of charges, which is not anymore a retrial as it was in the previous years of the court. It is also important to streamline the proceedings, and the court has made these qualitative and quantitative indicators for the judges, because it is clear that there are external factors which relate to the length of the proceedings, and it is not always the responsibility of the court, but the court has to make of the judges, but the court has to make sure that the delay of the proceedings is not the responsibility of the judges, but some external factors, as for example the cooperation of the states. As you know, the court does not have enforcement jurisdiction, but only adjudicative jurisdiction. So it depends a lot on external factors to have the effective proceedings. With regard to the question to the contempt of the court, I would favor the solution that the prosecution is in the hand of the prosecutor, not of the judges, even if it happens. And just because of that, if it happens at a trial with regard to offense to the contempt of the court, because that will ensure the impartiality and of the judges. The court has also made one amendment and propose it now to the Assembly of State Party with regards to that offense, and decided that only one judge has jurisdiction to try these offenses in the first instance. I think that's a correct resolution. I agree with this solution and think that one judge for such offenses would be enough, of course, with and possibility to appeal to the judicial chamber. As concerns the other questions, which is related to not prosecution of the, sorry, what was the other one?
I believe the question referred to a case where the prosecutor might decide not to proceed with a formal investigation.
This question is related to the right to effective investigation. It's one of the major rights of the victim, which has been introduced through the European Convention on Human Rights now in European Court of Human Rights. However, it's not applicable now at the ICC. The victims are the hallmark of this court. They have superior and extraordinary position with regard to the other international criminal courts, previous one. And they are involved in court proceedings from the beginning until the end. However, they cannot start and take over the criminal prosecution from the ICC prosecutor. I think that actually the ICC is the court which is under the constant review, critiques of the whole many states, academic community, judicial community, and although there is no legal maybe mechanism to make the ICC court to start the proceedings, I think there is such a pressure in some cases, and that it will be very difficult to have international criminal proceedings which is run by the victim. So I would stick to this solution that we have now, that the prosecution is in the hand of the ICC prosecutor. Thank you.
Thank you, Mr. Đurđević. Mr. Chagdaa, the same question regarding contributing to the further development of international criminal justice.
I believe that the most important goals ICC aspires to attain since its establishment until today was proving its efficiency freedom from political influence and its contribution to the international justice. However, the court was successful in fighting impunity by holding the perpetrators of the most serious crimes accountable and therefore proving its efficiency in this context. It is crucial to improve the level of cooperation with both member and non-member states, which is why efforts should be made to secure such cooperation for the successful implementation of the mandate of the court. Smooth collaboration is required specifically for the execution of arrest warrants issued by the ICC. In regards to the judgments of ICC's contribution to the international justice, I feel it's too early to come up with a definite answer considering ICC's lifespan. Thank you.
Thank you, Mr. Chagdaa. Ms. Bossa, can I ask you the same question?
Thank you very much. The offenses against the administration of justice, in my experience, there are mainly two of them: false testimony and contempt of court. These are important. It's important to ventilate these offenses when they occur, but the process of ventilating these offenses is somewhat difficult. Judges before whom the false testimony or contempt proceedings take place will also at some point sit in judgment of these offenses. But the prosecutor is also in a delicate position because he will most of the time be asked to investigate. But I suppose that to improve their process, if the prosecutor will be seen not to be independent in investigating these cases and prosecuting them at the same time, what the court can do, what the court can do is to make provision for the appointment of independent amicus curiae to investigate and prosecute. I must confess that I have not followed this procedure very closely with regard to the ICC, but I know that this is what used to happen at the ICTR. Also, they need to be given the same priority as the cases because they could endanger witnesses, they could endanger the proceedings. At the ICTR, because we had a fixed term within which to finish the cases, most of these cases were pushed to the end, and some were given over to, handed over to the residual mechanism for international criminal tribunals. I think the ideal situation would be to prosecute them side by side with the criminal trials that are going on because they are equally important for the administration of justice. Now, regarding the dissatisfaction with the office of the prosecutor, again, there are problems here because the prosecutor is supposed to be independent and not subject to the direction of anyone. Therefore, if the prosecutor decides not to prosecute, there isn't much that can be done. It's true that the victims will be left without a remedy, but I think the solution lies in continuing to identify prosecutors the process for selecting prosecutors needs to continue to be merit-based, so that when a prosecutor decides not to prosecute, it's a decision that is acceptable to all parties across the board, because everybody will know that this prosecutor is independent. He or she must have made the decision after weighing all the pros and cons, and therefore it's acceptable. And moreover, this is not the end of the matter. If the prosecutor comes up with more evidence in the future, the prosecutor can always reopen the case and prosecute it when he's more sure that he'll be able to prosecute it successfully. So for me, I don't see it as a disadvantage per se, because there could be genuine reasons for the prosecutor to decide not to proceed with the prosecution at a particular point in time. That will be my answer.
Thank you, Ms. Bossa. And the same question now to Ms. Majara.
Thank you very much. I'll start first with the issue of the failure by the prosecutor to investigate or prosecute certain offenses. I want to start from the premise that I think it is well known that at the ICC level, things are made doubly difficult because of the fact that the ICC is very much dependent on the cooperation of state parties insofar as allowing investigations to go on in their respective countries and supporting the court and the prosecutor with all the resources that they have. But taking a leaf from our own criminal and procedure back home, where the prosecutor seems to be reluctant to investigate and or prosecute an offense, the law makes provision for private prosecution, and that an individual can apply to the Director of Public Prosecutions for him to issue a certificate of nolle prosequi that I am declining to prosecute, so that the individual now is given the opportunity to appoint his own professional to prosecute the matter. So I think this is something that can be explored even at the international level, that where the prosecutor is failing to prosecute, especially for reasons that are not very clear, then victims are given the opportunity or the power or the authority to appoint their own lawyers to actually carry out the investigations and the prosecution. Of course, I'm aware that at the international level, it will be doubly difficult because it's already difficult even at the national level. But that is something to be explored and amendments to be proposed in that direction. That would be my take on that one. Insofar as the issue of contempt goes, in my experience back home, that is also the purview of the Director of Public Prosecutions or the defense, as the case may be, with the court only dealing with issues of contempt once they are brought before the court to deliberate on and try whoever is in contempt of court. It is not a judge-driven procedure or process. So I don't know how easy it would be for the court to actually follow up on the issue of compliance and enforcement to an extent that it would, of its own volition, want to take up a case of contempt, unless it also still falls under the office of the prosecution. Insofar as proposing amendments is concerned, I know that one of the biggest criticisms against the ICC is the length of time it takes for matters to be prosecuted and to be finalized. But once again, it goes back to the issue of the cooperation of state parties. But one thing that could be explored in terms of making proposals for amendments is to allow the matters to be as judge-driven as possible, so that judges are given more power in order to be able to curtail proceedings. For instance, from the experience that we have back home, where it becomes very apparent that the accused person or a defense lawyer is deliberately frustrating the proceedings by failure to attend, by requesting postponement, the judge is at liberty to actually go on with the proceedings in the absence of such accused person, or to order that a different counsel be appointed to proceed with the matter so that it reaches its finality. So I think those are the amendments that can be looked at. Which other question was it? Oh, the offenses under Article 70 on the administration of justice. We have offenses that are provided for in our own Penal Code and the Criminal Procedure and Evidence Act, where people come and give false testimony deliberately. The offense is called perjury. And at the end of the proceedings, the judge is at liberty to order that such a person, if it is is satisfied that he deliberately lied under oath, that person be tried for the offense of perjury. We also have the offense of obstruction of justice, which is also provided for. But most of the investigation and the prosecution still lies in the hands of the public prosecutor. So I think these are some of the experiences that we can bring to the International Court to see how much we can try and fit them in this court so that we can improve its efficiency and its speediness in dealing with trials. Thank you.
Thank you, Ms. Majara. Is there another question here in the audience here in The Hague? Somebody else who would like to ask a question of our panelists this morning? Okay, I see two hands, but I think the one here at the end is the first one I saw. Please use the microphone. Thank you.
Thank you and good morning, everybody. I'm Erika Lucero from the Embassy of Argentina. My question today is to the members of the panel. If they become elected at the next ASB, and you will have to interact with judges coming with the different legal backgrounds and with different influencing systems of law, being the main ones, the continental law and the common law. So how do you foresee the interaction between different legal backgrounds, and you think if there's the balance between the continental law and common law, this should be relevant, or do you have any different approach to that challenge? I would like to hear your views in that regard. Thank you.
Thank you. So the question, back to our candidates here, relates to the fact that the ICC is a system that brings together common and civil law, and what might be some of your reflections on that situation, particularly as judge, you would be confronted with those differences. Perhaps this round I will start with Ms. Bossa.
Thank you, Madam Moderator. The interaction between judges from different legal systems is a healthy development. If you consider collegiality, which is a professional duty imposed on judges to be collegial to others, there should be no problem synchronizing them, because there are the rules of procedure, there are the rules of evidence. They are a hybrid system of rules, borrowing from both civil and common law jurisdictions and others. They should be able to guide the judges to reach a decision. I have been interacting with judges from different legal systems, both in the International Criminal Tribunal for Rwanda, the African Court of Human and People's Rights, and I'm always amazed that the concept of justice is the same. We might use different routes to reason, but we always see justice the same way. As long as the facts reveal commission of an offense and the burden of proof is discharged, I'm yet to confront a situation where we will fail to agree on a verdict. Be that as it may, sometimes you may approach a case with different perspectives, not necessarily because you come from different legal systems, but because of the way you think or you consider the gravity or the simplicity of the problem. But we have this power of persuasion in deliberations. You listen to your colleagues, and sometimes you will be persuaded to their side, or you put your side to them, and sometimes they will be persuaded to your side. So I think the thing is to listen to your colleagues, think about what they have said, because as long as you have not made a decision, you are free to change your mind, and be guided by the sense of justice and apply the law to the facts. And I think that a decision will be quickly made. And of course, this requires respect for your colleagues and also listening skills to what your other colleagues have to say. Thank you.
Thank you, Ms. Bossa. Ms. Đurđević, can I ask you to address this question?
The ICC has mixed criminal proceedings, meaning that it is composed of the institutes coming from the civil law countries and common law countries too. The civil law institutes or principles are more represented than it was the case in the previous predecessor of the ICC, than it was the case for the ICTY or ICTR, where mainly common law principles and common law tradition was prevailing. So it is necessary to have the judges which are coming from the civil law countries and common law countries, and this is actually the strength of the court, because the court is already global. Decisions are implemented, and its law, it's the model in different countries all over the world, which have civil law systems and common law system. Although through my education and I'm working in a civil law country, I have also deep knowledge and expertise also in the common law common law tradition, especially as I had my master's degree in criminology at the University of Cambridge 20 years ago, where I also followed and passed the courses in criminal law and criminal procedure in United Kingdom, England especially. Then I was at the University of Berkeley and also at the Yale Law School for 2 years, where I actually was conducting the research related to the comparative law, comparing integration of the criminal proceedings in the United States and European Union. I also use this opportunity, being at one of the best law schools in the world, to follow and participate in the courses like evidence and the procedure in the United States, and also the criminal proceedings and adjudication, which also gave me really possibility to understand better the common law criminal proceedings. And this gave me also the experience, and I'm completely aware that coming from the different legal systems, something what is completely unacceptable in your system can be completely normal or required in other legal system. So you really have to be able to cooperate with judges coming from the other country to understand their different perspective and to find compromise which would be then acceptable for different legal system, but also which will attain or fulfill the international requirements for the human rights standards. Thank you.
Thank you, Mr. Đurđević. Ms. Majara, can you address this question, please?
Thank you. I think first and foremost, we should always remember that judges are professional. And the fact that they come from different systems and they bring different experiences, to me, should be seen as an added strength and advantage rather than a disadvantage, which when pulled together, they will simply complement one another. And I would want to echo what Justice Bossa has already said, that we, as judges, come from jurisdictions where we serve in the Supreme Courts, which sit as panels. That is why at times you will have dissenting judgments. That is a true testimony of judicial independence. But like he correctly said, as long as you respect each other, you know how to communicate properly, I think the diversity should be used as an added advantage rather than to be seen as a disadvantage. So I think that is a strength rather than a weakness. Thank you.
Thank you, Ms. Majara. And Mr. Chagdaa.
I have accurate substantial amount of knowledge about common law system during my LLM program and continued internship at the district court in the United States. Although historically Mongolia has always belonged to a civil law system, due to recent major judicial reform, Mongolian criminal justice system has adopted multiple elements from common law jurisdiction. Due to extensive knowledge of the U.S. common law system, I think there will not be high barriers for developing a relation and work together with other colleagues for me. Thank you.
Thank you. I believe there was a question over here. Yes, thank you.
Thank you. My name is Bridget Inder. I'm with the Women's Initiatives for Gender Justice. Thank you so far to all the panelists and your presentations. As you know, the ICC is an international justice institution which works in a highly political global context. The commission of the crimes within the jurisdiction of the court, and therefore the consideration of situations and cases, occur in politicized and complex environments. So in that sense, the credibility of the ICC is directly connected to the independence of the court, the ability to navigate the politics, and ensure the impartiality and independence of the judiciary and the court as a whole. So our question is, as a judge on the ICC, how would you consider these issues and ensure your independence?
Thank you. So the question relates to an international judicial mechanism operating in a political climate, and how will you as candidates, if you were to be judge at the ICC, address this important issue? Mr. Chagdaa, can I ask you to address this question?
Can I answer that a little bit later?
Okay. Perhaps Ms. Majara, if you wouldn't mind addressing this question first then.
Judicial independence. Judicial independence given the high political stakes. I think that is nothing new for any judge, because even at the national level, my take would be that sometimes it is even worse. The pressures are even more than at the international level. So for me, actually serving in the ICC would actually prove much better than serving at the national level, because there the types of pressures are not really at a personal level, but they will be aimed at the entire court, which will be easier to absorb and easier to deal with and easier to navigate. But I cannot pretend that it will not bring certain challenges to the judges. But insofar as their judicial independence is concerned, I think it is guaranteed, because normally judges will not be dealing with situations that they are more familiar with, that they are sometimes even more intimate with, serving within their own national jurisdictions. So once again, I think that is an advantage rather than a disadvantage.
Okay, Mr. Chagdaa?
From the beginning, ICC has had to face questions of legitimacy, including its independence from the political influence. For instance, a rise in referrals from the UN Security Council, a highly political body, could potentially undermine ICC's reputation. There are many other issues that push the court into political thicket, such as the geographical focus of its case law and the codification of the crime of aggressive war. Thank you.
Thank you, Mr. Chagdaa. Mr. Đurđević.
Independence of the judges is the paramount value and necessary characteristic of any court, and especially International Criminal Court. As concerned judges, I think they are not in such a difficult position as the prosecutor is, which has been criticized, whatever decision she makes for selectivity and political influence. However, as concerned judges, the judges has to make their decision based on the law, which they have to implement, and based on the evidence which is in front of them. So no other legal arguments, of course. So no other influence on or no other decision or any kind of interference should relate to their decisions. However, with the ICC, it raises one more challenge, which hasn't been the case with regard to previous international criminal courts. This is the first court which doesn't have a competence to adopt rule of procedure and evidence. So for ICTY and ICTR, their judges were competent to adopt also the rules on procedure and evidence. That has its advantages and disadvantages. However, as concerns ICC, there were several times actually that Assembly of State parties have adopted or attempted to adopt, but didn't succeed, the rules of evidence and procedure which were related to the cases in front of the judges, and interfere actually in this way in the decision-making of the judges, especially with regard to some issues such as admissibility of evidence and presence of the defendant at the trial, which, from my perspective, would be in the competence of the judges and not of the states, some of which are also actually participating in the proceedings in the way of cooperation with the court. So, however, this hasn't happened in the last Assembly of State parties, and we can only hope that it won't happen in the future also, because this can be a danger for the independence of the judges who are sentencing and deciding in the cases, in the current cases. Thank you.
Thank you. And Ms. Bossa, the same question, please.
Thank you, Madam Moderator, and thank you for the question. Independence is very important for the credibility of the court, and various aspects ensure the independence of a judge. The legal framework, the oath of office, but most importantly, the mind of the judge. The judge must determine a case free of any interference from any quarter. And therefore, if a judge feels that, talking about myself, if a case was before me, what I would look at, as my colleague has said, are the facts and the law and the justice that this case requires. And then I will decide that case. I must dispel all the baggage that I have, because we all come from different backgrounds, and sometimes we have convictions, we have biases in this and that. All that must not be imported into the case. I must approach a case with a free mind to listen to the parties, identify the facts, apply the law, and then make a decision independent of any other factor. Thank you.
Thank you, Ms. Bossa. We have a question over here, please, Ambassador.
Thank you very much for this organizing this meeting, which is very useful, and it will be very fruitful for our own decisions. I'm a representative of Chile, and I would like to ask you about how do you envision and how do you see the relationship with the Assembly of State parties? We have already heard some or listened some comments about the possibility of interference, but there is also a broader picture of the relationship between the Assembly and the court and the organs of the court. The mission of the Assembly is not only a political one, it's also a legal one. And there is the power for elections, there is a power for the approval of the budget, but it's also a kind of supervision of what the court is doing. And the assembly is essential to achieve the inclusion of further other states that are not already part of the statute. And that is a tremendous challenge. And for that, the ASP could work together with the court or could work in isolation. So I would like to ask you about how do you see this relationship between this body, which is diplomatic, political, but also legal one, and working in an institution, which is a complex system, and the court and you as judges? Thank you.
Thank you, Ambassador. So the question relates to how the bench, how you as potential judges before the ICC see your relationship with the Assembly of States Parties, which is not only a political entity, as has already been evoked, but also has an oversight role over the operations of the court and has legal characteristics as well. So, Mr. Chagdaa, can I ask you to address this question first, please?
I'm skipping this question. Can I skip this question?
You prefer not to address this question? Okay, very well. Then may I ask Ms. Bossa if you would be prepared to answer this question? Thank you.
Thank you very much for the question. The relationship between the Assembly of State Parties and the court can be a tightrope at some, if I may use the expression. The Assembly of State Parties is sort of the legislative arm of the court. It determines the budget. It determines, it has a role to play politically in selling the court, as you have rightly said. But for me, I see it as one of partnership. We should be close, but at the same time distant, because we don't want the Assembly of State Parties to interfere in the work of the court, but at the same time, they are responsible for providing for the court. And each of the parties here has a role to play, and to respect each other's role, so that we don't step on each other's toes. The Assembly must provide sufficient funds for the court to operate, provide a conducive atmosphere for all the arms of the court to play their rightful roles, and to craft rules that will enable the court to dispense justice fairly and with the necessary speed, and also play its political role to ensure that between members of the Assembly of State Parties, there is rapport and understanding, so that the court does not get bogged down in deciding cases concerning partner states and the court. Now, the court also has a role as far as the Assembly of State Parties is concerned, which, as I've said, should be close, but distant at the same time. The court has to recognize the role of the Assembly of State Parties and to defer to them whenever any amendments are necessary, point to them and sell them to the Assembly of State Parties, and to make a case for most of the funding that the court needs in areas that may be covered or may not be covered at the moment. So it's a partnership. It might be like marriage. There are difficult patches, there are good patches, but I think it's a necessary relationship and should be nurtured and improved from both sides. Thank you.
Thank you, Ms. Bossa. Ms. Majara, can you address this question, please?
Thank you, Madam Moderator. The relationship between the International Criminal Court and the Assembly of State Parties, I think it can be compared with the relationship between judiciaries at the national level and the executive. there are always bound to be some tensions between the two. But that doesn't necessarily mean they cannot complement each other, in the sense that the one, being the Assembly of State Parties, have to ensure that the court has all the requisite resources to be able to execute its mandate without any hindrance. But also the fact that the Assembly of State Parties is made up of different states with different expectations, with different political muscle and power, I think that also is helpful in the sense that I don't foresee at any one given level where all the state parties would be wanting the same thing from the court or expecting the same. So in a way, I think the fact that the state parties are numerous, it also works to the advantage of the ICC in that they will also be able to rein each other in to try and ensure that the ICC is left to carry out its mandate without unnecessary influence and duress. So once the judges have been elected, I think, although I'm not very familiar with the rules now that govern their security of tenure, but I believe those are there to ensure that judges are protected and cushioned from undue influence. So that if even the possibility of removal, which normally is the biggest fear for any judicial officer, wouldn't be a hanging threat over their heads. But otherwise, I think there will always be a healthy tension between the two, while at the same time, they will be complementing each other to the best of their ability. Thank you.
Thank you, Ms. Majara. Ms. Đurđević.
We talked already about the Assembly of State Party as a legislative arm for the ICC. But there are also the other perspectives or aspects which are also very, very important. And these are the budgetary issues, which you have mentioned in your question, but also the cooperation. So the ICC, the Assembly of State Party can influence, of course, the court by giving more or less resources, which has been an issue in the last years, and on that way, of course, influence on the performance of the court and the activities which the court is able to perform. It is also an overview mechanism which has to ensure, of course, that the court is an effective and efficient institution. However, the Assembly of State Party has a great responsibility with regard to cooperation. We know that in last, maybe even the 10 years, there were cases of non-cooperation of the state parties with the ICC. For these reasons, we have like 15 arrest warrants which has not been executed, and also we have some procedures which have failed because of the non-cooperation of the states. The Assembly of State Party has done a lot to deal with this issue. It has introduced the Bureau on Non-Cooperation, procedures for non-cooperation, focal points, and also many other mechanisms. However, I think that the Assembly of State Parties has to assume the responsibility of the implementation of the court's decisions. The court cannot by itself execute its decision. It is on the state parties and Assembly of State Party, particularly taking into account that the ICC is not subsidiary organ of the Security Council, as was the case with ICTY and ICTR. So even not in the cases of referrals from the Security Council, we can see that there is complete non-action on the part of the Security Council. So Assembly of State Party, where we have now 124 states, is a very powerful institution which should make everything possible to make the cooperation to work and the court to succeed in its proceedings. It's the greatest challenge, I would say, for the court, but even more for the Assembly of State Party. It's not the fault of the court that its decision has not been implemented. it's more responsibility of the Security Council, but also Assembly of State Parties. Thank you.
Thank you. I think we have a question over here, please.
Thank you very much and good morning. I'm cheating a little bit because I work for the Coalition for the International Criminal Court. My name is Elise Villemain and I would like to ask the panel if I may ask you to describe any experience you may have had, in dealing with sexual and gender-based violence, or any experience you may have had in applying a gender perspective to your work. Thank you.
Thank you, Alix. So the question relates to experience prosecuting or dealing with crimes related to sexual and gender-based violence. And I'd like to ask Ms. Majara to be our first respondent to that question. Thank you.
Well, having started my career as a professional magistrate, I have dealt a lot with cases involving gender-based violence, rape cases, and all the other offenses that are related. And not only have I dealt with those cases as a judicial officer, I've also been an activist, like I said in my introduction, that I, at one stage, was a research associate with Women and Law in Southern Africa and Research Trust, where among some of the studies that we made was directly with respect to gender-based violence against women and young children. So we were examining how the law affects women, how it responds to the needs of women, how all the different justice structures respond to women, how people perceive gender-based violence, and what are the challenges with regard to providing remedies for women. And I think I have a lengthy experience insofar as that is concerned, because even as a judge of the High Court, in terms of our Criminal Procedure and Evidence Act, rape is actually a capital offense. Although to date, no one has ever been sentenced to death, in the sense that all nations are trying to move away from prescribing the death penalty, but it still remains in our statute books and in our constitution. But rape is regarded as a very serious offense. And I think some of the work of other activists like myself has had a large influence in the passing of what came to be known as the Sexual Offences Act, in which, because a lot of people had been complaining about the way offenses of the sexual nature had been relegated to minor offenses, and the statute aimed to prescribe more serious punishment and to give more voice to the victims of sexual violence, as well as to make provision in certain cases or specific cases with the advent of HIV and AIDS for people to be taken for treatment as soon as possible. So I have dealt with those. I have made orders in terms of that law. And even under the common law, I have dealt with many cases of sexual violence. Thank you.
Thank you, Ms. Majara. Ms. Bossa.
Thank you. I've dealt with cases of sexual offenses and gender-based violence for a very long time. First as an advocate in private legal practice. As I have already informed you, I was an activist, and we dealt a lot with women who were married and who were threatened with rape by their husbands who had already been infected with HIV. So we worked with the Federation of Women Lawyers to ensure that we protect these women through court orders, and I represented quite a number of them in courts because most of them were indigent. As a judge, I've handled, at the national level, I handle capital offenses, which include rape and defilement, although now there has been an amendment to give some of this jurisdiction to magistrates' courts. Rape is a very serious problem in our countries because women are viewed as objects that should be part of a man's possessions to be dealt with as and how the men like it. So we have a lot of challenges educating men about seeing women as human, respecting their rights because they have their own rights as women, talking about their rights to reproductive health and things like that, and security in the home. I've also addressed rape as a weapon of repression and subjugation in conflict situations. Rape manifests in all sorts of scenarios as genocide, as a crime against humanity, as a war crime. And I'm happy to see that the ICC statute has articulated most of these various manifestations of rape more clearly than the statutes of the ad hoc tribunals. Rape and gender-based violence has serious implications for people who are victims of it because they suffer moral, physical, and health repercussions, which nobody can really ever repair. So I'm happy that the UN Security Council has come up with a resolution urging all countries to ensure that they prosecute war crimes and grave crime and pay more attention to these sexual and gender-based crimes. At the domestic level, we need to do more because we need to have all the statutes that are necessary to avoid domestic violence in place. Some of them have not been passed in my own country, like we're still agitating for the succession law to be put in place, to be amended so that it complies with the international standards. The Domestic Violence Act is also still an issue, but we need to have all this legal framework in place, both at the national level and international level, so that we can deal with this animal because it's really rampant and it's causing a lot of problems worldwide. Thank you.
Thank you, Ms. Bossa. Mr. Chagdaa.
One of the outcomes of difficult socioeconomic conditions formed after the collapse of legal and political systems in Mongolia in 1990s was the increase of illegal activities that subsequently undermined the security of the most vulnerable groups of the society, women and children. My involvement in this area was both as legal counsel and as a judge, as I mentioned before, in human trafficking cases, particularly involving women and children with the purpose of sexual exploitation, which were taking place during economic and political transition period in Mongolia. Also, I handled numerous cases with crimes of serious sexual and gender-based violence and the myriad of cases of rape and forced prostitution and sexual slavery. As a judge, I have always strived to protect the rights of the weak and vulnerable persons, especially if women and children were involved. From my experience, I came to understand that victims of this sort of crimes require a very delicate approach when being examined before the court. For instance, in case of human trafficking with the purpose of sexual exploitation, I found it is imperative to consider the consequences of being a victim of such a crime. These victims often become very vulnerable and hesitant to provide all the details of the crime, which in turn generates serious impact on examination of the evidence. This has to be carefully considered during examination before the court. Thank you.
Thank you, Mr. Chagdaa and Mr. Đurđević.
During my professional life, I always put much emphasis on gender perspective, violence against women and discrimination of women. Within the criminal procedural law, I have written a lot of papers and also did the research about the procedural rights of the victims in the sex violence offenses and domestic violence. So I have participated, actually I was the president of the expert group of the Ministry of Justice in Croatia to introduce procedural guarantees of the victims of gender offenses, such as right to counsel, although you are a victim, not a defendant, right that counsel will be funded from the state, right to privacy of your data, right to ask for exclusion of the public while giving the testimony. Also, Croatia has introduced in 2008 the possibility of guilty plea for all offenses. However, in 2013, under my presidency, this expert group, and by my proposition, it has been adopted that this guilty plea can be accepted only if the victim consent. So no guilty plea in the sex offenses and violence against women offenses without the consent of the victim. Also, I have a long-standing cooperation with the NGO in Croatia, which are dealing with gender offenses and violence against women. So particularly, I have given a lot of lectures and participated in the education in this field. And also, I have written the study about the implementation of the Convention for Prevention and Combative of Violence Against Women and Domestic Violence, so-called Istanbul Convention. And have written the study about all the requirements which has to be changed in Croatian legal system in order that this convention be implemented, which unfortunately hasn't been implemented yet. I also dealt with this issue with regard to right to effective investigation. As we all know, one of the major problems is around the world that these kind of offenses are not always and in all cases prosecuted and tried and sentenced. So I wrote a book about the judgment of the European Court of Human Rights with regard to right to effective investigation in sex offenses and violence against women when the Croatian cases, but there are other cases also, when the states did not investigate and sentence the perpetrators of these offenses, and then the state has to pay compensation, but also change its law, but also the practice in these cases. I'm aware that that high on the agenda of the ICC prosecutor, but also the court, is the violence against women and discrimination against women, and the judges of the ICC has made some very important decisions with regard to these offenses to make them offenses under the jurisdiction of the ICC statute equal to all other violation of the physical and integrity of the victims. Thank you.
Thank you. I think we can have one more question addressed to our panel. So I see a hand being raised over here. Sir, if I can just ask you to be brief, because I know that we are running out of time. And then as I still have the microphone, and if I can just kindly ask all of those who are taking the floor to try to speak a little bit more slowly so that the interpretation can be as smooth as possible. Thank you. Sir?
Thank you very much. Reinhard Hassenflug from the Embassy of Germany. I would like to come back perhaps to the first question addressed to the panel, which related to the administration of justice. I think one of the panelists mentioned the issue or the term of performance indicators, and probably you are aware that the court, the ICC, is working on a system of performance indicators for the entire court, and I would like to ask to the panelists, what do you think of this development, especially with regard to the idea to have performance indicators which could evaluate the achievement of certain strategic goals, also in particular related to judicial activities of the courts, the trial proceedings of the chambers. Thank you very much.
Thank you very much. So the question relates to the examination underway at the court related to performance indicators and measuring the performance of the court. Perhaps I can ask Ms. Đurđević to address this question first.
Yes, I am aware that the court is working on these issues. It was quite fascinating, actually, for me to read the report of the court on the proceedings with the section and classification of every act and every proceedings and how long it lasts and what was the reason for not being in a term that it should be. It certainly put a great pressure for the court. We have to always have in mind, and for the judges, we have to always have in mind that the length of the proceedings does not depend on the judges in the most of the cases. The cases which we have now in front of the ICC are lasting 5, 6, 7, 8 years. This certainly violates the right of the defendant on a reasonable length of criminal proceedings. But this was the case also in all previous international criminal courts, and this is one of the major problems. And we cannot reconcile actually this right to the reasonable duration of the criminal proceedings with the aim of the court to have the effective and efficient proceedings. However, the major problems is the cooperation in the previous international criminal courts and in this one too. So it's not always about the work of the judges, but it's about the cooperation. There are many external factors which influence the evolution and the development of the criminal proceedings. However, the judges has to do everything to not to delay the proceedings, and it must be shown also to the state parties that if the proceedings are so long, it's not the fault or responsibility of the judges, but some other issues. It is, I think, a good development. It will help the court to improve and to be more efficient. However, how the proceedings are very complex, and I am not sure that it will be clear for everyone that in some cases it is not the responsibility of the judges, but of some external factor as collecting the evidence or implementing the arrest warrant or execution or any other decision of the court. Thank you.
Thank you. Ms. Bossa, perhaps you can address this question now?
Thank you. Performance indicators are, I understand them to be some sort of evaluation of one's work. And I think that it's important to take stock of where one is, why you are there, where you should be going, and how you should get there. So if performance indicators can assist us in this regard, for them, because we have them at the national level as well. We sit together with our bosses and decide on average, after taking into account all the pros and cons, the roadblocks and what should facilitate our work, we decide the amount of work we should be able to dispose of in a given period. So I think that it's an important innovation, and I think it will assist the court to move forward with its work with necessary speed and fairness. But it's not enough to introduce them for the judges only. As my colleague has pointed out, all the other arms of the court need to be on the same page. because if the judges have the performance indicators and the prosecutors don't, or if other players who should be moving forward the trials are not on the same page, it will be a problem. So this should be across the board and it should be accepted by all. Thank you.
Thank you. Ms. Majara.
Thank you. I would like to agree that the performance indicators may exert some pressure on the judges. But as long as the aim is not to exert undue pressure on them, but they are used rather as a tool that can be used to try and identify where maybe the challenges, the weaknesses, the gaps of the court are, with the aim to suggesting appropriate amendments in order to strengthen the court and to make it more efficient, then I think they would be very much useful. And I should also echo the first two speakers that because the criminal justice system is not dependent on the one organ of the court, but on the various organs. If it is a universal tool, then I think it will be more efficient than if it is aimed at only the judges. Thank you.
Thank you. And Mr. Chagdaa. Okay, you would not like to answer that question. Sorry, very well. Well, I believe this concludes this panel session as we are nearing closure at 12 p.m. I would like to extend my sincere appreciation to all of the panelists for taking part in these panel discussions. I think it has been useful for all those present and those watching via social media. I'd also like to thank once again the host state of the Netherlands and particularly the Ministry of Foreign Affairs for welcoming us in this impressive location, and also extend heartfelt thanks to the interpreters up there who have been tirelessly working to translate this very intensive and interesting discussion. We will now break for a short light lunch that I believe is going to be held just outside the doors. We will reconvene at 1:30 with our second panel, which will feature the judicial candidates Ms. Alapini Gansu, Ms. Akane, Mr. Vukoje, and Ms. Ibanez. I thank you all for taking part in our first panel discussion this morning and look forward to reconvening here again at 1:30. Thank you very much.